Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I should be able to cover a vast, diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please feel free to get in touch with me here live or on the show today. Two ways to get in touch. One is to call on the landline number which appears at the bottom of the screen. If you call on the landline number, your call will be put through to me live on air and I will be able to address your questions live on air. Alternatively, second very popular way of getting in touch is to send a message, a WhatsApp message, text message on that mobile number, which is also at the bottom of the screen. Your message will be sent through to me here live on air and I will be able to address your question here live as the show goes on. As I answer your question, if you're still not clear, by all means you can send a follow-up question, or as always you can pick up the phone and give me a ring on that landline number which is there at the bottom of the screen. A couple of minor points before we get going. On a live show, sometimes it's a bit difficult to deal with complex matters. So if your matter is complex, or if I need to look at documents before I can advise you, I'm more than happy to have a more thorough discussion with you or look at your documents off air. And I'll leave your number and I'll ask you to leave your number with our control room. I will give you a ring and I can then look at your documents or have an in-depth discussion with you off air. As always, this is a service that we provide, which is absolutely free of charge and part of the free legal advice show. One other minor point before we get going. Obviously, please do feel free to call in and ask me any questions that you have. If you're not sure about the advice that we provide here, please do get advice from an independent solicitor on all legal matters. So there we are. That's our introductions done. As always, we have loads of questions coming in on immigration law matters, which is fantastic. So please do keep on sending those questions in. Okay, let's look at some of the questions that have come in. And as I've said, immigration law is very, very popular, which is absolutely fine. By all means, do send those questions in. But even if they're non-immigration law related matters, you can also send those questions in. Okay. Let's look at one of the first questions that's come in. Immigration law matter, and one to do with delay. Delay on the part of the Home Office. Now, to be quite honest, currently in practice, and most solicitors will advise you of this, that they are getting numerous questions at the moment from clients regarding how long applications are taking to be decided, how long it's taking for appeals to be heard, etc. So delay is a major issue. Let's look at the question that's coming on delay. So the question is this. Dear sir, we submitted an indefinite leave to remain application in December 2020, went for biometrics in 2021 in Birmingham at one of the approved centres. We've not received any confirmation from the Home Office. What's the waiting time for a decision on a matter like ours? So the question really is, the application is submitted for indefinite leave to remain in December 2020. Biometrics, where you enroll your biometrics, where your fingerprints are taken, where your photograph is taken, digital photograph is taken. That happens in January, a month later. So we are now in September, end of September 2021. So we're now 9 months down the line and our viewer hasn't received a decision yet. Two issues. We've not received any confirmation from the Home Office. Well, to be quite honest, the Home Office doesn't send acknowledgement emails in most cases. What's the waiting time? In my experience, straightforward applications are being decided in about 3 to 4 months. More complex matters could take 8-9 months. Now, you've been waiting a long time. If you still don't get a decision within the next couple of weeks, a couple of things you can do. You can write to the Home Office and request an update, Or another popular way of trying to find out what's going on, you may not get a quick decision, but you might get to find out what's going on, is to contact your local MP and get your MP to get in touch with the Home Office to ask for an update. Let's look at the next question that's come in. The question is this. Our viewer starts, I have a question, please can you assist? If you're the father of a British-born child, when the child reaches the age of 7, can the father apply for permanent stay? And to get permanent stay, does the father have to be in the UK, or can he apply if he is living outside the country? What are the requirements? Please explain. Okay. I think there might be some slight confusion as to what the rules actually say. So what our viewer is asking is, if you're the father of a British child, a British-born child, and the child reaches the age of 7, as the father, are you able to get permanent stay in the United Kingdom? So obviously the starting point is, I mean, this information isn't here in the message, but the starting point obviously is this, that the father either doesn't have any kind of immigration status to be in the UK, or if the father does have some kind of immigration status, leave to remain, it appears to be temporary immigration status. So it's might be a limited leave to remain. So father, I think we can assume, either has no immigration status in the United Kingdom or has only limited leave to remain. Hence the question about whether a British child, when the British child reaches the age of 7, can the father get permanent stay? So the father's interested in permanent stay. Now, I'll deal with the question about the country later as to whether it makes a difference whether the father's abroad or whether the father's in the United Kingdom. I'll deal with the location point later. But the general position is this. In terms of a British child and how having a British child can be a basis for your leave to remain or your permanent stay in the United Kingdom, the first thing I should point out is the British child turning 7 doesn't make a difference. Any rights that you can get, any type of leave that you can get as a result of, or on the basis of a child that's British, those rights are going to exist on the basis that the child is British. It doesn't matter whether the child is a year old, 5 years old, 10 years old. So the age of the child isn't really going to make a difference. The fact that the child is British, it could be a basis upon which the father can apply for some kind of leave to remain in the United Kingdom. So one is the child's age doesn't make a difference. I think the confusion has arisen because where somebody has overstayed in the United Kingdom and they want to apply for some kind of leave to remain based on their child, then if they have a child that is British, or the child isn't British but has lived in the UK for 7 years. So on the one hand, either the child is British or the child has lived in the UK for 7 years and isn't British, the father or the parents could make their limited leave to remain application based on that, on a British child or on a child who's lived in the UK for 7 years. So it's either or that you need. So a British child who reaches the age of 7 years isn't really going to strengthen your application. So let's say, for example, let's give some examples because we don't have enough information here. The father is in the United Kingdom and the father is an overstayer. If the father has a child that is British, potentially the father could make an application for leave to remain based on the child. Father would either need to be living with the child, or if the father isn't living with the child, the father would need to be having some kind of contact with the child on a regular basis. Now, there are obviously other rules surrounding this scenario. There are requirements that need to be fulfilled. But for the benefit of our viewers, in very basic terms, if there is a father, mother here and they've overstayed in the United Kingdom, if they have a child that is British, then they can make a leave to remain application. They can get some kind of visa based on the child. Now, if somebody already has leave to remain in the United Kingdom, then the reality is it's not really going to make a difference. It could be that they already have some kind of leave to remain based on their British child. So they're on this 10-year route to settlement. They've got a visa because they've got a child. The fact that the child reaches the age of 7 isn't going to make a difference. If you've already got leave to remain based on your child, then you will be on a particular route to settlement. Normally, there are exceptions, normally the route to settlement will be a 10-year route to settlement normally. So it will take you 10 years to qualify for indefinite leave to remain. The fact that whilst you've got leave to remain based on your British child and your child has now turned 7 isn't going to make a difference. Your route to settlement will most likely be a 10-year route to settlement, and you're going to have to live in the United Kingdom for 10 years, continue to have live with the child, or alternatively continue to have contact with the child, and on that basis you will get your permanent stay after 10 years. So that's the scenario that we have here. Somebody who has no leave to remain can potentially make an application based on having a child that is British. Somebody who's already got leave to remain based on their British child, to them it's not going to make a difference if their child turns 7. They will remain on that route to settlement where they will get settlement after 10 years. So hope that answers the question as far as a father who is in the UK is concerned with a British child. Let's look at the other scenario that's been posed here as well, which is where the father is abroad. What kind of visa can the father get if you have a child who is British in the United Kingdom? Now, I'll look at this in greater detail after we've taken a short break. We're going to be back in the next couple of minutes. We'll address this and all the other questions which have been coming through in the next couple of minutes after we've had our short break. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air with any legal questions that you have, please ring on the landline number which appears at the bottom of the screen. Alternatively, as always, any questions that you want to send in as a text message or WhatsApp message, you can do so on the mobile number which appears at the bottom of the screen. That's a very popular way of getting in touch. Sometimes people don't want to come on air live and discuss their confidential, sensitive issues. And we found over the last few months, or last year or so, that it's a very popular way of people getting in touch. It's an easy way. You send in your question and I get to see it here live on air, and then I can address that as we're live. And you can send any follow-up questions as well in relation to your query. Okay, it may be possible, and this is quite complex, but it may be possible for the father to apply for a visa from outside the UK in order to come and live with the child, or in order to have contact with the child here in the United Kingdom. There are requirements that need to be fulfilled, and these are quite tricky applications. If you're outside the UK as the father and you have a child here in the UK, and I'm assuming you're not with the mother, and any application will be based solely on the child, it is possible. There are quite difficult rules which need to be fulfilled. Potentially, and I've seen this in practice, that where the father is abroad, maybe the relationship with the mother has broken down. The mother isn't going to sponsor the father's application to come to the UK, but there is a child. Now, if it can be demonstrated, for example, that mother, whoever's looking after the child, is giving permission for father to be with the child, either live with the child or have contact with the child, and other requirements in terms of finances, accommodation can be fulfilled, then it is possible for father to get a visa from abroad to come to the UK. Now that visa that's granted, it's not a visa which is indefinite leave to enter or indefinite leave to remain. It's again a temporary type visa. You are granted limited leave to enter for 2.5. You get a 2.5-year visa effectively. It's extended after 2.5 years, assuming all the requirements can be fulfilled. Potentially after 5 years, you can qualify for indefinite leave to remain. So it's not possible to get permanent stay, and that's really what our viewer was asking. So hope that answers the question. Obviously, we had quite limited information. 2 scenarios here where the father is here in the United Kingdom. There are things that can be done to get leave to remain based on a child, not permanent stay. And if father is abroad, if there is a British child, potentially that there are applications that can be made if certain requirements are fulfilled. Potentially father could come here on the basis of the British child. Now, these are quite complex matters, and like our viewer, if you do find yourself in a situation where you're looking at making these type of applications, I would advise that you do seek legal advice from an immigration specialist, because these are quite complex matters. But thank you very much for that question. Very interesting question. Okay, let's look at the next question that's come in. Now, the next question that's come in relates to further leave to remain. And what our viewer is asking is this. In terms of our further leave to remain application that we need to submit in the next 2 months, can you confirm what type of application needs to be submitted, where the link can be found, and in basic terms, what the requirements are of that application? Okay, so further leave to remain, I'm assuming somebody's here on a spouse visa in the United Kingdom. As our viewers will be aware, those who have gone through this situation, if you have a spouse visa, you get a 2.5-year visa. You come to the United Kingdom, you live in the United Kingdom for 2.5 years with your partner. At the 2.5-year mark, you then apply for an extension of your visa. And the extension is again for 2.5 years. And after you've completed those 2.5 years, a total of 5 years in the United Kingdom, you're eligible for indefinite leave to remain. So that's the background. The way spouse visas are now granted, they have a system whereby you qualify for indefinite leave after 5 years. And it's in 2 blocks of 2.5 years. Initial 2.5 years, extended for 2.5 years, and then after a total of 5 years, you qualify for indefinite leave to remain. And the question that's been put is, at the extension stage, what type of application do you submit and what are the requirements? Well, the first bit is relatively easy in terms of what kind of application do you submit. As our viewers will be aware, anybody who's gone through the immigration process recently, all applications currently are done online. So you don't have the paper forms that you used to have, so it's all done online. So what I would advise is that you go online, and for the extension, you look for a form which is known as FLRM. It stands for Further Leave to Remain Based on Marriage. It's an FLRM form that you need to complete. So if you Google that, it will take you to the government website and it will take you to this relevant online form. So that's the easy bit. It's the FLRM form, which is on the government website, which needs to be completed. It's all done online. You don't submit a paper form as such to the Home Office. The submission is done via the online form that's completed. Payments are made as well online. So it's the FLRM form. I was looking at the issue in relation to further leave to remain applications. And I explained that at the 2.5-year mark, when a spouse has been here in the UK for 2.5 years, you need to submit a further leave to remain application. And our viewer wanted to know where they could find the link to the form. And I advised that with the help of Google, if you put in FLRM, it should take you to the government website and you should be able to access the online form there. Now, slightly more complicated is, what are the requirements which need to be fulfilled when you apply for further leave to remain. Now, quite a generic, general question. Now, I'll try and address it as best I can. Now, a lot depends on your own personal circumstances as to how you meet the requirements. If I give you a general idea, that in practice, what I tend to look at is on the extension application, as I normally see it, there are three things generally that you need to focus on, assuming obviously you're with your partner and you know, hopefully there's no problem with the marriage, etc. So it's not, we're not in a tricky situation. It's a standard kind of extension application. I tend to focus on three things when it comes to an extension application. First of all, how are we going to meet the financial requirement? And I'll look at that in greater detail later on. But how are we going to meet the financial requirement? That's normally the trickiest part. That's where most of the problems arise. Finances, whether it's at the initial spouse application stage when you're sponsoring your husband or wife to come to the UK, extension stage or indefinite leave to remain stage, in practice, most of the problems are with finances. So you're at this stage where you're looking at submitting an extension application. Three things. First of all, as I've said, we look at finances. How will the financial requirement be met? Secondly, slightly easier in practice is will the applicant, be able to meet the English language requirement? Generally straightforward. When you've come to the United Kingdom, you would have done an A1 level test in English. We're at the extension stage now. The English requirement is slightly higher. Instead of the A1 test that you did before, on this occasion, you'd be doing an A2 test. In practice, it's not a problem. So that's the second thing that you look at. Finances is the first thing. Second thing in practice you look at is the English language requirement. Third matter, shouldn't really cause a problem, is whether you can demonstrate, you as a couple, that you've been living together. And that's normally done by submitting documentary evidence, letters and bills received at the same address over the last 2.5 years, either in your own names or in joint names. Again, in practice, that's not normally problematic. So there are obviously other requirements which need to be fulfilled. There are other documents which need to be submitted, passports and marriage certificates and children's birth certificates, and issue about accommodation. But generally speaking, in practice, at the extension stage, those are not major issues. Even accommodation, the accommodation requirement has to be fulfilled, but the Home Office's approach on accommodation is quite flexible. So in reality, in answer to your question, what are the requirements? But there are a number of requirements, but in reality, we need to focus on three things: finances, the English language requirement, and can you demonstrate that you are living together by way of documents coming to you and your partner at the same address. Now, on finances, the problem I've got is I don't have enough information here in the WhatsApp message in order to give you specific advice as to how the financial requirement can be met. So let me just speak to you in very, very general terms. I know we've got numerous other questions coming in, but let me just talk about this in general terms. That the financial requirement can be met in various ways, and it depends on your own circumstances. Normally, the starting point is, and you would have heard this many times been mentioned on this show, or if you've gone through it, your lawyer would have advised you on this. Generally speaking, your income needs to be £18,600 per annum, either your own income or your income combined with your partner's. You would have heard about this £18,600 requirement. That's generally the requirement that needs to be fulfilled. Again, there's an exception to that where you're in receipt of certain disability type benefits. So that's why when it comes to finances, if your matter is anything other than straightforward, you should really speak to an immigration lawyer. Now, finances. In a general scenario, if you're employed by your employer, and if you're employed for a while, more than 6 months, all you're submitting is 6 months of wage slips, 6 months of bank statements, and an employment letter. That's quite straightforward, but life isn't that straightforward. You might have changed jobs. Your income might be through self-employment. You may be the director of a company. You might be receiving income from properties that you have let out on rent. You might be receiving dividends from shares. You might have significant savings. You might be receiving disability benefits. You might be receiving carers allowance. So it's difficult to advise on the financial requirement here without specific details. What I'm trying to get across is, look, I'll look at the requirements after we come back from our break, because that's quite a complex matter. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, as always, another popular way of getting in touch with us is to send us a message on our WhatsApp number, which is there at the bottom of the screen as well. Very popular way. Understand a lot of people don't want to come live on air. And they prefer to send messages in, which is fantastic. Your messages do come through to me here live on air, and I can address your questions live. If after I've answered your question or tried to answer your question, if you're not sure, please do come back to me with another follow-up question on WhatsApp. Or alternatively, as always, you can give me a ring on the landline number and speak to me live. If your case is anything other than straightforward on finances, you should get advice, because the reason really for that is there are various different ways in which the financial requirement can be fulfilled. But I hope that gives you a good overview in terms of how the financial requirement or a further leave to remain application is dealt with. Now, I do need to move on. We've got numerous questions coming in. Let's look at the next question. The question is this. I did my biometrics about 3 months ago. But I'm still waiting for a reply. I really need my British passport back. Can I ask the Home Office for a quick decision? Now, we don't really have enough information here. But look, let me address it in a couple of different ways so that it helps you. If you're not sure, do come back to me. If you've submitted an application and you're British, so the application that's been submitted is your partner's application. Let's say, for example, we don't have enough information here, but let me try and work out where I think you're coming from. You're British, you've submitted an application on behalf of your wife or your partner. Whilst the application is pending, if you need your passport back, you should be able to request your passport back. Now, in most applications, you don't submit your original passport anyway, so you should already have your passport. It may be possible that the application that's been submitted is some kind of nationality application where you've done an online application on behalf, or you've done a paper form application on behalf of your partner. You've submitted hard copies of documents in the post. Now, if that's the case, and I don't have enough information here, if it's the case that your passport's gone in with your partner's application, you need the passport back, there is a way of getting the passport back. You need to make a request online. So if you go onto the Home Office website, there is an online form which can be completed where you can request the return of your documents. So when you ask for the return of your documents, it will ask you a series of questions. Name of the applicant, when the application was submitted, a reference number, or if the documents were sent in recorded delivery or special delivery, the tracking number, etc. So you submit an online form, which is on the Home Office website, to request your documents back. So I'm assuming that there is some kind of application that's been submitted. I'm assuming it's your partner's application that's been submitted, possibly for nationality, where hard copies of documents have been submitted. You want the documents back from the Home Office. The easiest way is to use the online form to do that. Now, so that's what you need to do, to complete the online form, request your documents back. Now, if you still have no joy, you're trying, the Home Office isn't responding, and if you really need it back quickly, you could go to your MP and ask your MP to intervene and to request a copy of the passport. So the person who sent the question in has now clarified. Thank you very much for that. I assume, so it does say it is for a citizenship application. So my guess was correct. I mean, nationality applications is one of the few applications remaining where you can submit a paper form along with along with your original documents. I mean, to be quite honest, in practice, most lawyers have stopped submitting paper forms for this very reason, that clients do need passports back, they need to travel urgently, etc. And it's sometimes a bit difficult to get the passport back from the Home Office. Now, I know we can't do this now, but one option would have been, when you were looking at the nationality application, to simply have done the online form for nationality. If you'd done that, your British passport would simply have been scanned and uploaded. Your partner's passport, again, would be scanned and uploaded. So you'd keep your passport in your possession. So this is the reason why we advise clients that it's better to do the online form for nationality. You keep your documents. If you need to travel, you can travel. So, but thank you very much for clarifying that. I understand it's part of a citizenship application. I'm assuming it's your partner's application. You're British. You've sent your passport in. You need it back. Now, as I've said, in a bit of detail, please do go on to the government website. There is a way of requesting your passport back. You submit that. You're expected to wait 14 days. If you don't receive a reply, you then submit another request to the Home Office and you say, please, can this be accelerated now? Because I need it in an emergency. If you still don't get it back, you can phone the Home Office up. Every time you submit the online form, you'll have a reference number. You can tell the Home Office when you phone them up, look, I've made the request. These are my reference numbers. I've not had it back. They may be able to chase it up for you. If you still have no joy and it is urgent, and sometimes it is urgent, you have family members who are unwell abroad, you need to travel, etc. If that's the case, if you're really struggling, contact your local MP's office, ask the caseworker there to get in touch. So I hope that if you do need your passport back, you will follow these steps, submit the online requests, contact the Home Office, and then if you have no joy, contact the caseworker. Hopefully that should be able to resolve your matter. Now, if you're not clear about the advice that I've given, do come back to me. That I want my citizenship application to be determined as quickly as possible. I need my citizenship for whatever reason. The problem there is it's going to be difficult really to get the Home Office to get a move on quickly to get your citizenship application approved. They do checks, and it does take a while sometimes to get them to complete their checks and to come back to you. So it does take a while. Now, let me give you an idea that in terms of citizen applications, at the moment, in my experience, they seem to be taking around 4 to 5 months. And bear in mind that once the application is approved for citizenship, you will still be required to attend a ceremony, a citizenship ceremony, before you are given your British citizenship. So there is, even after the Home Office approves your application, there is still another process that you need to go through. They will approve it in principle. You will need to attend the citizenship ceremony. And then after that, obviously, you will get your citizenship. And then there's another step. You then have to apply for a British passport. I mean, the British passport stage at the end doesn't take more than 10 days or so. So that's not too bad. But look, if you really need your citizenship for whatever reason and you're struggling to get it, in reality, there probably isn't much you can do. You can write to the Home Office, you can contact the Home Office, but in reality, it's very difficult to try and get the Home Office to get a move on citizenship applications. It's one of those applications where they do go through quite thorough checks before they grant citizenship. So hopefully that answers your question. If my answer isn't clear, by all means, please do come back to me. Now, number of other questions coming in. Another interesting question coming in regarding EU nationals and settled status. Let me have a look at the questions live with you on air. Question is this: I am a Spanish citizen. I have settled status. I would like to sponsor my wife and 2 children from Spain to come to the United Kingdom. Interesting question. Spanish citizen, with settled status. The wife and children are still abroad, and our Spanish citizen here wants to apply for indefinite, wants to sponsor the wife and children to come to the United Kingdom. Now, to be quite honest, this would have been so much easier had this been done prior to the 30th of June 2021. Easier because as an EU citizen with settled status, pre-settled status, there would have been no fee to pay at all. There would have been no English language requirement to fulfill at all. There would have been no TB test requirement at all. And best of all, there would be no financial requirement to meet either. So it would have been much easier to get this application in prior to the end of June 2021. No fee to pay, no English test, no TB test, no financial requirement to meet. A simple application to get your wife and 2 children in the United Kingdom. Now, unfortunately, that deadline's passed. So there is still a possibility, I mean, that's the good news, you can sponsor your wife and children to come to the UK. It doesn't matter whether you've got settled status or pre-settled status. Even if you've got pre-settled status, you can still sponsor your wife and your children to come to the United Kingdom. The problem is this, that your application, I know you're an EU citizen, your application will be dealt with, will be treated in the same way as the application of a British citizen or somebody with indefinite leave to remain sponsoring their wife and children to come to the UK. So all the requirements that British citizens have had to meet, you're now going to have to meet as well. So the previous advantage that you would have had as an EU citizen, no fees to pay, no English test to do, no TB test to do, no financial requirement to meet, those advantages are no more. You have to make a standard application. But the good news is you can still do it. Let me just run through what the basic requirements are going to be, the major matters that you need to look at. First of all is going to be the fees. A typical application for entry clearance, whether your partner is in Spain, India, Pakistan, Dubai, wherever it is. Typically, per person, the Home Office fees, made up of the application fee, the NHS fee contribution, is in the region of £3,650 per person, which could have been saved if the application was made prior to the end of June 2021. So we're looking at just the Home Office fees of something in the region of £10,000, a significant amount of money. Secondly, your wife would need to meet the English language requirement, so she's going to have to do that. We're going to be taking a short break. We'll be back in the next couple of minutes. Inshallah, see you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen, and to speak to me or send me a message, sorry, I should say, you can do so on the mobile number. In practice, maybe that's not that big an issue. Vast majority of people are able to meet the English language requirement. The biggest issue here is the fees involved. And the second issue is really in terms of finances. And I flagged that up because the slight problem we have here is that if it's just your spouse that you're sponsoring to come to the UK, the financial requirement, generally speaking, is that you need to be earning £18,600 per annum. But with 2 children, the financial requirement is much more. You need to be earning just under £25,000 from the top of my head. Off the top of my head, I should say, it's £24,800 that you need to be earning in order to sponsor your wife and your 2 children to come to the United Kingdom. So look, I'll run through the requirements, but basically this is where we are because the application wasn't submitted prior to the end of June 2021. Significant fees are going to have to be paid, which could have been saved if the application was made earlier. And there is a financial requirement to be met. Just under £25,000 has to be your earnings in order to meet the financial requirement. Now, as always, and I say this all the time, depending on your circumstances, there may be other issues, there may be other ways you can meet the financial requirement. But generally speaking, the reason I flag this up is, in practice, we still have EU citizens who are in the United Kingdom approaching us for advice. And unfortunately, they still think that the way that they could sponsor, EU citizens could sponsor family members to come to the United Kingdom still exists. The easy way in which they were able to sponsor their partners, their children under the age of 21, their parents, their grandparents, on some occasions extended family members such as brothers, nephews and nieces. I still think that that still is possible, but it's no longer possible. You're only really able to sponsor your spouse and your children now under the age of 18. All the other categories have now fallen away. And even when you're sponsoring your partner and your children under the age of 18, you are now applying in the same way as somebody who is a British citizen or has indefinite leave to remain. So, the typical requirement as to submitting evidence as to English, the TB requirement, the financial requirement, accommodation requirement, proving that the relationship is genuine and subsisting, all of that continues to apply. So, look, there is good and bad news. The good news is that you can still apply. The slight problem is that it is expensive to do, and you're having to meet the quite difficult requirements that people in the UK have to meet. Okay, hope that answers your question. Interesting question, because we continue to get similar questions from European citizens. Right, let's look at the next question that's come in. And again, an immigration matter, which is fantastic. There's no problem. But even if your matter relates to non-immigration matters, you can send your questions in. Look, okay, the question is as follows. Assalamu alaikum. I am considering applying for my wife's visa, who is abroad at the moment. I have been on a period of furlough, where I have been receiving 80% of pay. Will I be able to sponsor my wife whilst I've been on furlough and rely on my wage slips, furlough wage slips? Now, the short answer is potentially yes. Now, as our viewers will be aware, when you're sponsoring a husband or wife to come to the United Kingdom, one of the biggest issues is finances. Generally speaking, you need to be working. And I say this all the time, this requirement that generally needs to be met is that you need to be earning £18,600 per annum. You can potentially use your furlough pay in order to meet the requirement. I'll look at that in greater detail after we've taken our next call. Hello, assalamu alaikum. Hello.
I just wanted to ask you a question.
Sure.
And just take some advice off you, please.
Sure. Yeah, fire away.
Jazakallah. Basically, what it was, it's regarding wills.
Okay.
My granddad, he passed away in 2016.
Okay.
And he had a son and one daughter. The daughter is my mother.
Okay.
The son is his son was my uncle.
Okay.
It was my granddad's house, freehold.
Okay.
He passed away without a will.
Okay.
And we didn't know, but my uncle applied for a, grant of probate.
I understand, yeah.
Take everything. And now he's refusing to give my mother a share. So
are you very sure that there was no will at all?
I checked it online. You can check online.
You can do. Yes, you can do. Yep.
Yeah. So I checked online.
Okay. So what's happened? What's happened is he potentially inherits under from the estate, like your mother would inherit under the estate. So that would give him the right to apply for probate, which is done. But that doesn't mean that he keeps everything just because he has applied for probate. Somebody who's died without a will, there are strict rules as to how the estate is divided up. In very general terms, I'm not an expert on wills and probate, but in very general terms, if it's two children who are left behind,
Yes.
generally I would work on the basis that it's going to be, the estate would be split 50-50. I mean, it may be that there are other family members, I may not be 100% accurate, but the point is this, that just because he's applied for probate doesn't mean he inherits the whole estate at all.
Okay.
How far has the administration of the estate, how far has it got? I mean, what was in the estate?
Okay. Sorry. Basically, my grandfather had a house.
I understand. Yeah.
And yes, he had two kids. He had one son, one daughter.
Yeah.
But my uncle, yeah, he's got the probate, and he's also sold his house.
The granddad's
So
house.
he's managed to sell my grandfather's house.
Okay,
So he's got some control here.
Okay, he sold the house. What's he done with the money?
I don't know, but he's refusing to give the money.
Okay, and I'm assuming that the property would have probably been owned mortgage-free. I'm assuming, so there was.
That's correct. It was a freehold.
Roughly, just very roughly speaking, in terms of money-wise, what are we talking about? Value of the house, 100,000, 200,000?
About 100,000. Yeah.
So potentially, there's a lot of money at stake here. It's not an insignificant amount. And in terms of the uncle, does he have assets in the UK? So if you had to pursue him, would you be able to pursue him for something? Does he have a house here? Does he have anything here in the UK?
I think he's got a property here. He's got a couple of properties here.
Okay, so it's not like he's going to be able to get rid of assets and disappear as such. So, I mean, to be quite honest, to me it sounds like a fairly clear case where he took on the responsibility of dealing with his dad's estate, and he hasn't administered the estate properly. There are certain duties on him. So whoever inherits where somebody dies without a will, whoever deals with the probate has to divide or share out the property properly. And if it means selling the house, fine, the house is sold, but the money then has to be divided. So if it's 1/3, then it's divided 1/3. If it's half, he keeps half and your mother gets half. Now, what is done is appears to be wrong. Unfortunately, you do come across this in practice quite a bit. I think initially, obviously, you'd speak to him. I suspect he's going to ignore you. You may have to take legal action against him. And the reason I was trying to find out is does your uncle have any assets? I was trying to work out whether it's worth pursuing him or not. To me, it looks like it definitely is worth pursuing him. Because I think what he's done is incorrect legally. Now, if you can't resolve it amicably, you're going to have to speak to a lawyer, not a lawyer who does wills and probate, but somebody who deals with probate litigation. That's what you're going to have to do.
Okay.
But to me, it looks like absolutely, I mean, I don't know the details, but on the face of it, to me, it looks like this is something that you should really pursue. I can't see how, if there's no will, he can't take 100% when there are other children. So there's no mortgage on the property. Property's been sold. And he can't keep it all. As a minimum, he's going to, whatever his share is a share that the daughter, your mum, would have. So there, without looking at this in any greater detail, to me that suggests that there is a share that would have gone to your mother, which is kept. And he's got money, he's got assets, so it's worth pursuing him. Obviously, if it can be resolved amicably, you want to do that. But if it can't, you've got to pursue it. You can't leave this. I mean, and I just advising on this a couple of days ago to somebody, there's no point leaving this because it's not going to get resolved. You're going to have to see a lawyer. It may cost, 5,000, 10,000, but a dispute of this size potentially, it seems to me to be worth spending £5,000-10,000 on. Because I personally think that, if you instruct lawyers to deal with it, he will see sense and there's no way out of it. He will, hopefully he's a sensible man, and he will, resolve this without it going to court. But you've got to take the first step. Otherwise, this ain't going to get sorted out.
Sure.
Definitely, look, it's been a couple of years. 16, I think you said, grandfather died. You should really speak to a lawyer who deals with these kind of matters.
Jazakallah.
No problem.
I'm just gonna quickly say, because it's been, we have obviously approached him several times. He's refusing. We've obviously got a fatwa. We've asked him for a third of the share. He's still refusing. So obviously we are trying to pursue it. So we were looking at legal. I
think you have to, and you're in time. You've got to do it.
Sorry, but we just wanted to check, because it's been a long time. He sold the property a couple of years back.
It doesn't matter.
Would it? If you went to court, would they say, why have you waited so long?
No, it doesn't. Brother, I'm really sorry, we're coming to the end of the show. But it doesn't matter that you waited this long. Your right doesn't disappear simply because you waited a few years. But as I said, you do need to pursue this now. The delay isn't an issue at all. It's only been 4 or 5 years. So do get on with it. That brings us to the end of the show.